Well, the complaint that was filed was that the federal government as an employer discriminated against its gay and lesbian employees who were not able to put their same-sex spousal partners on the benefits plan. You were prohibited from doing that because your spouse was defined as someone of the opposite sex.
It just snowballed. It started from a case of a couple here, and Dale and Alex in BC, just looking for benefits for themselves. And it grew from that into something that was going to transform the not just granting of benefits to gays and lesbians, but granting recognition and status by even allowing them to use the word spouse for the first time.
This was quite important at the time because there had been efforts to seek relief under human rights statutes on the basis of family status. And that argument largely failed. And so until there was an acceptance that human rights legislation must be read up to include sexual orientation, a lot of those claims were doomed to failure.
What was interesting about the Akerstrom case is up until Akerstrom, my memory is that PSAC, was the Public Service Alliance of Canada, was not very involved in human rights cases because the attitude or the policy was at the time counsel was provided to the complainants by the Human Rights Commission. And so the PSAC was not actively working with human rights complaints because the belief or the thought was that anyone who was filing a human rights complaint was going to be represented by legal counsel from the Commission, and our focus was elsewhere. Akerstrom changed that.
The no discrimination clause came in during negotiations for the master agreement, and it was a small step in the right direction. But of course, one of the big missing parts was the same-sex benefits, and that came in subsequently in 1989.
Well, I started working for the federal government in 1990, and Alex and I got together that year, towards the end of that year, and after we'd been together for a year, I knew that year of being with someone was the definition of a common law spouse as far as federal government benefit stuff goes. And so it was actually 1992, so we'd been together almost 2 years, that I thought I would apply to put Alex on my benefits plan. But of course, you couldn't do that. It was refused because the benefits plan specifically excluded same-sex partners of employees from being registered for payment of benefits like the extended health or the dental or the medical things.
We went on our posting in 1991 in the summer. And just prior to that, there was a change in the collective agreement between the government and PAFSO, the Foreign Service Association, where they added a non-discrimination clause, which said that all of the provisions and clauses outlined in this collective agreement will not discriminate against anyone based on sex, religion, age, or sexual orientation. That was a new addition. So based on that, Pierre and I decided to apply to have the expenses that we incurred in him accompanying me, to have those covered by Foreign Affairs. Up to that time, they were tolerant in allowing Pierre to join me. But they would not recognize him at all.
The decision covered the federal government in Canada, so it meant the complaint, my complaint was combined with Stan Moore's complaint because his covered Canadian employees who were working outside of Canada. federal government employees who were working outside of Canada, because Stan worked with the Foreign Service. By combining the two complaints, it covered all federal government employees, whether in Canada or outside of Canada, that the benefits plan that the federal government provided to all of its employees had to be non-discriminatory on the basis of sexual orientation. And so that was the first time that sort of equal access to those benefits was extended to all federal government employees across Canada or abroad.
There was really very little going on at that point in the public service. I mean, there were no benefits being provided, not only abroad but domestically. So I think what began to encourage us was introduction of clauses such as the one that Stan mentioned earlier, saying that there was to be no discrimination. So we made the assumption from that we could apply for benefits that were being provided to opposite sex couples, which we did. And in fact, I remember distinctly sending a telex to Ottawa, asking them which benefits we would be entitled to, given this new clause, and they responded, well, that was not the intent of the clause. It was just to give equal standing. And we then asked, well, then what's the purpose of the clause? And we never got a response. Not a word.
It left us as being people with no real identity. There was just an aura of confusion as to how to treat us. For example, in the house that we were given was appropriate to a single individual because I was considered single, and we were just fortunate that there happened to be a queen-size bed in that place, or we wouldn't have been able to get one. But even things like the water was polluted in Jakarta, and the Health Canada had inspected the well that was available at this house and had condemned the water and said that that house needed to be provided with bottled water. And so even there, the water that was given was appropriate only for one person, not for two. So they wouldn't even give pure water.
I think to understand Akerstrom and Moore and how it evolved in the jurisprudence around same-sex rights and benefits, you have to understand where the Charter of Rights and Freedoms was at that time. Charter came in the early 80s. We didn't have a whole lot of guidance from the Supreme Court of Canada on how it was to be applied in practical terms until around the middle 80s. And it was only at that point, 86, 87, that people started thinking about using the Charter to further human rights causes and cases.
There was a lot of frustration within the membership, the lesbian and gay membership, right through most of the 80s, when there was a push for equal rights. But the courts were really not going along. They were interpreting matters in the most restrictive and absurd ways. There was one court case in Manitoba in '88, Court of Appeal case, I think, Vogel, where the judge actually said that even though the requirement of a spouse being of the opposite sex had the effect of denying benefits to gay and lesbian employees, it was not discrimination because those gay and lesbian employees had the same right to that benefit. All they had to do was to have an opposite sex partner. And he was saying this seriously, so the state of things was pretty bad, and people could have given up because there was a solid no until the late 80s, early 90s.
And so, as cases were running through the courts addressing these issues and human rights standards were qualified, the issue of sexual orientation arose in the early 90s and came on like gangbusters between about 1990 and 1999.
Well, there were breakthroughs, and that's what I was saying. It was, you know, the PSAC, we were just one child of many children that were taking on this. But now, as I say, in retrospect, it just seems so ridiculous we had to do it. But let's back up when we had to do it. There were unions that were taking cases, and there were cases which we all were excited about that we didn't initiate.
Yeah, there was a split in the union for those who believed it was legit to have same-sex benefits, and those who thought that if we put that in, that it might take away some of the benefits they could achieve. Now, the split wasn't a major split except for some of the bargaining unit.
One of the things that you really have to understand as respondents, Treasury Board took the position that we were jointly liable, and there could be a significant financial repercussion from this case.
When I filed my human rights complaint, I named both the union and the federal government as respondents because the collective agreement didn't allow for same-sex spousal benefits. And because the union is a party to the collective agreement, I named both of them in that.
So you have on one side, the PSAC is very supportive of what Brother Akerstrom was trying to accomplish. On the other side, there was a very real sense of this could cost us a fortune. And that was one of the interesting things, at least for me in a legal sense, came out of this case, because up until then, Renault was out there, where a union was found by simply signing a collective agreement which was discriminatory to have discriminated itself. And so we had to sit down first and get directions from the elected leadership of the PSAC what our position was going to be in Akerstrom.
And what that did then, when it came to the Human Rights Tribunal for the hearing, the union was able to bring forward all of its information on how it had been working on through the 80s, trying to get these kinds of benefits into the collective agreement and how they had basically been refused by the federal government. So it allowed them to present that information as part of their defense to avoid liability in the complaint.
And in normal circumstances, where a collective agreement is found to be human rights offensive, it's a contract. It's a contract between two astute parties. And so normally the liability that should flow from that should be equally on the shoulders of both the employer and the union. What we were able to do, and I think do so convincingly, was demonstrate that, at least in the case of PSAC, whose case I put in, had been lobbying to change this definition of spouse in the collective agreement, to open up the collective agreement to not just opposite-sex spouses, but same-sex spouses. And we were able to demonstrate that, and the only reason that those collective agreement changes hadn't been made was because the government refused.
During the 80s, late 80s and the early 90s, I think the biggest thing was that the gay and lesbians were getting really active in the union. They were really pushing, and as I say, I will admit that it took a while to get me to understand it. And when I pursued it with them, it actually made a big difference. Because now that I understood the situation, knew it was discrimination, then I was able to talk to CLC, or Canadian Labour Congress as an example, and a number of the leaders there were able to then grasp it.
The reason that the Alliance was active on this front, the way it should be, is that members, a certain segment of the membership, supported by many others, really got out there and they were filing the grievances, they were making the demands, they were educating the leadership of the Alliance, as well as the staff and everyone else, on the need for this type of activity and action to obtain simply the same rights that everyone else had.
And at one of the CLC conventions, there was about 4 major leaders, including myself, who got up and spoke openly against it, the discrimination. And that certainly made a difference for all of the other unions.
One of the things that I remember that was fun on that case is we anticipated that what the government would come back before the tribunal and say, you've only got one bargaining, maybe the largest bargaining agent in the federal public service sitting in front of you, but you don't know what the other bargaining agents think. So you can't assume what the PSAC says is an ideal way to amend a collective agreement is what something everyone else would agree to. And we anticipated they might say that. And so there was actually a National Joint Council meeting, and President Bean and his assistant Mike McDonald, we drafted up language, essentially same-sex spousal language, and they went around to every president of every bargaining agent of the federal public service, and they all signed it. And so then when that argument was made by the government, then we tabled this document that had been signed by every president of every bargaining agent of the federal public service, saying we all believe there shouldn't be saying the definition of spouse should drop.
Solidarity.
Yes, well, and it was fun the way it worked, and that was the sort of thing where we were thinking ahead. But then again, that was all, you know. You had the president of a very large national union going around knocking on doors to make sure that we had that exhibit, and we had it.
Yeah, all 17 bargaining agents. Right?
Yeah, they all signed.
The first decision that upheld the complaints was in June of '96, and the parties, the employer and the unions, were required to fix this problem in their collective agreements and in the healthcare plan and so on. And the government proposed a way of dealing with this by creating a whole new status called same-sex partner. The government did not want to amend the definition of spouse to remove the requirement of opposite sex. They wanted to leave that, but they wanted to provide the same rights with another definition called same-sex partner. And the unions and the complainants were extremely troubled by that because it just exacerbated the existing discrimination. It fundamentally did not accept gay and lesbian couples as being spouses. And that issue went before the tribunal about a year later, and the government said, look, in terms of the making available these benefits, same-sex and opposite-sex couples are treated the same. And we said, perhaps, but you're still using a definition of spouse which is human rights offensive, and the tribunal accepted that in a very articulate paragraph in the second decision about a year later.
This was during the Human Rights Tribunal segment of our challenge, and the three judges who were part of the panel, the tribunal panel, asked me how I had felt as an accompanying person with Stanley, and I said, well, you know, I didn't feel terribly good because my status was in fact less than that of an animal. And so all three of them looked at me quite incredulously and said, well, what would you mean by that? And I said, well, they covered all of the expenses of our household cat, Lady Jasmine, the travel expenses, her inoculations, whatever she needed. But when it came to me, it was a big fat 0, which meant that she had far more status than I did. So how does one feel when one's status is less than that of an animal? Not so great. And I remember the poor lawyer representing the government side of this whole debate shaking his head and looking quite despondent at that stage.
The Attorney General of Canada was represented by 2 lawyers. They both were quite up to date an understanding of the evolution of these issues in the human rights context. So they did not come at this issue from an extremely right of center position. Their arguments were more nuanced. One of the principal arguments the government advanced was that because the case of Egan had been lost on the basis of Section 1 of the Charter, which was a chartered case, that the Human Rights Tribunal should follow the same essential process of thinking, and on that basis reject these complaints. Counsel for the government never took the position that the Canadian Human Rights Act should not properly be interpreted as including sexual orientation as a prohibited ground.
One of the arguments that was made is if you open the doors to same-sex spousal benefits, it was going to cost a fortune. And I can give one anecdote from the tribunal, actually. Well, there are two things going on. At that point, there was a huge surplus in the pension plan. That was before the government gutted it. So there was a huge surplus to start with, but there was an exchange between Justice Counsel, who was making this argument to the tribunal, the worst case scenario, if this should happen, this is, there's no way it can be paid. And the response of PSAC counsel, who was Mr. Raven, as I recall, he said, well, think of all the money you've saved all these years you've discriminated against them. And there was just silence. But yeah, it was a bogus argument. There was the reality was there were benefits in the collective agreements, and those benefits were for all the employees of the federal government. And there was a segment of that group which the government had just essentially been refusing to pay and saving money by doing so. It was to say that we can't afford this is just ridiculous. And it was ridiculous then, and I think the response of PSAC counsel was appropriate at the time. It certainly closed down the argument at tribunal, as I recall.
The government's defenses on pure issues of law were, firstly, that because the Supreme Court of Canada in Egan had rejected a charter attack to the Old Age Security Act, that the tribunal should follow the same essential approach. And what we were able to convince the tribunal to do was to understand that there's a difference between a charter attack on legislation, which by definition gives the government some latitude in terms of what benefits it will provide and what it won't, and human rights standards, which govern, for example, how the government functions as an employer. That distinction was huge, and so our arguments, which were accepted by the tribunal, is we're not dealing with the government here as the government passing legislation. We're dealing here with the government as an employer, and it's subject to exactly the same standards as any other employer subject to human rights legislation. So that was an important legal issue which the tribunal had to deal with. And the second we've talked about briefly, and that is the government argued that because sexual orientation wasn't written into the Human Rights Act until 1992, there should be no remedy given to Mr. Akerstrom and Mr. Moore for any discrimination prior to that. And we took that issue head on. And of course, the short answer to that argument is this wasn't new legislation. This was a declaration that the existing legislation was charter offensive. And if it was charter offensive in 1992, it was charter offensive in 1982 when the charter came in. And that's what the tribunal accepted. So that's another example of an area where a respondent union like PSAC, and I'll say here and now, Catherine McLean was there for PAFSO and PIPS, the late Catherine McLean, and she did a great job as well for her clients. So it was a pretty united front that we presented And we were able to respond, I think, meaningfully to some of the technical arguments the government was offering to oppose the sustaining of these complaints.
I think the issue that really bothered me about it was that when I came to work, you know, after the weekend off, or I was working shifts, but whenever you come back after your leave, people would always talk about what they did with their families or their significant other or whatever that, and I always felt like I couldn't do that because I wasn't able to say that, you know, I have a gay partner, so this is what we did. And that's the part of it that bothered me to the point where I thought, it's not fair to have to edit out these sort of major details of my life because it's different from my colleagues, and because my employer doesn't really support me being in a gay relationship. So
I think when the issues are individual issues, you get a settlement often because the government doesn't want that precedent to be used in another case. But where you have a case which is raising systemic issues that affect everybody, then they're there to fight you all the way. That's been my experience.
D'abord, lorsque nous avons entrepris notre lutte, ce qui nous avait guidé initialement, c'était l'accès aux avantages sociaux, parce qu'on croyait que c'était là qu'il y avait une discrimination. Mais avec la poursuite de la lutte, là, on s'est rendu compte que la lutte était plus large que cela, que la définition de conjoint de fait, la définition de conjoint allait entrer en jeu.
Like it or not, between us and Dale Ackerstrom and other champions of gay rights, you take on a poster boy element that you didn't seek. It's just sort of given to you, and so you become reluctant champions, whereas we first started with just concerned about ourselves and others like us, and wanted to deal with it as privately as possible. But once your case becomes the test case for the whole of the country, you can't be very private anymore.
I am very pleased with the work that was done to get same-sex benefits, and if I want to be totally frank, I didn't understand it at first. And when I understood it, I can tell you that I certainly pursued it. I'm proud of what the union did.
For workers, it was the unions. It never would have come to the courts if it weren't for the unions. It never would have been considered by them.
You know, it was really different sections of the union working very closely together. We couldn't work in a silo and have ever come out with this victory. And I'm
It's very satisfying
and the activists, which we've talked about already, because they were in the committees, they were coming forward, they were changing the resolutions. There was a resolution very early in the 80s coming out of the PSAC that we had to change this. So that engine, the engine of what happened in Akerstrom 10 years later, I suppose, it started with the membership passing a resolution that the PSAC had to take this on.
A lot of hard work, but worth it.
It was very satisfying in that way because it worked the way it should. It really was from the membership. And the leadership was principled and supportive. And the staff was interested. It was a real privilege to be in the position where you could be on the right side and push for things and actually make some progress within what, as these things go, was a relatively short period of time. It seemed like a long time, certainly a long time for people denied basic benefits and rights.
And it was the unions that pushed for this. It was the unions that tried to extend the inclusiveness of the collective agreements to include everybody. including gays and lesbians. And I just can't say enough about that.
We live in a country where we have a lot of guarantees of equality and equal rights, but it seemed like there was a number of things, at least in the 90s, that were still lagging behind, and that was one of them, that gay families weren't considered equal to straight families. And so myself and my same-sex spouse, common law spouse, were not seen as a family the same way as my colleague and their straight common law spouse. And I just wanted to make that, to eliminate that difference in the way our families were viewed.
You have no idea how good I feel about being a Canadian. I never for the life of me thought that I would have to call upon the services of the Canadian Human Rights Commission. And yet, because I did, I have nothing but admiration for our system and for our country. We are just so privileged to be Canadians.